All right, good to go, Jim?
Yes.
Hi, everyone. Thanks for joining us today. My name is Hugh McDermott. I'm the Communications Manager with Michigan EGLE, Department of Environment, Great Lakes, and Energy. Today, we're joined by Attorney General Dana Nessel, EGLE Director Liesl Clark, and DNR Director Dan Eichinger to discuss a significant new development in the Edenville and Sanford dam failures. I'm not about to steal their thunder, so I do want to run through a couple of quick housekeeping tips. Everyone on the call is muted. Our technical team will unmute speakers' microphones as necessary. This press conference is being recorded, and that recording will be available shortly after the conclusion of the press conference. So if you'd like, reach out to me or Public Information or Nick Assendelf, who's also on the call. If there is time after the presentations, we'll take a few questions. I know we've only got a half an hour, so I don't know how many we'll get through. And also, there should be a press release coming out shortly. It may already be in your inboxes. I'm not quite sure. But you should get that if you haven't already during the course of this conference. So at this point, I'd like to turn it over to Dana Nessel, Attorney General of the State of Michigan. Dana?
Thanks, Hugh. Much appreciated. So good afternoon, everyone. So let me begin by saying that I've been disheartened by recent accounts of the Edenville Dam failure that are factually inaccurate and that have allowed Boyce Hydro Power LLC and other LLCs owned and controlled by Lee Mueller to avoid what should have been swift, sweeping, and universal condemnation after years of its grossly negligent and defiant actions. Now, as many of you know at this point, Boyce has a well-documented record of repeatedly and intentionally ignoring state and federal safety regulators. When Boyce's actions resulted in the very harm that these regulators sought to prevent, Boyce then had the audacity to blame these individuals for its own misdeeds. And rather than focusing their anger on the entity that owned and operated the dam, an entity that repeatedly put its own profits over the safety of the public, some people have instead chosen to use this as an opportunity to score political points by repeating Boyce's self-serving propaganda at the expense of the truth. But when you cut through all the noise and you focus on the facts, it's clear that legal responsibility for the failure of the dam rests solely with the owner of the dam, period. And that's why I am pleased to be here today, joining Director Clark and Director Eichinger to announce a new lawsuit that we filed against Boyce to hold it accountable for its massive neglect. Now, before I talk about our new lawsuit, though, I want to take this opportunity to address some of the questions we've received at our office over the course of the past few weeks. First, the breach of the Edenville Dam is solely attributable to Boyce's negligence. It is not the result of any action or inaction by the state of Michigan. Second, though the state did file a lawsuit against Boyce Hydro, it was after Boyce had already raised the lake's level. The state lawsuit did not seek to raise the water level in the lake, and this fictional narrative was created by Boyce to try to distract from its own misdeeds, and it is easily disproven simply by reviewing the pleadings filed in the state's case. And let me say this, the great thing about any lawsuit is that, again, you have pleadings that are filed. Everything that takes place on the record where there is a transcript of those proceedings. And of course, just like in our lawsuit that we're filing today that we're here to talk about, there is something at the end of the complaint called relief requested, or sometimes it's called a prayer for relief. And you can actually look there to see what it is that the plaintiff in the lawsuit is seeking. And I would suggest to anybody when they wonder about what our lawsuit that was filed earlier in the year was about, they can simply look to the pleadings to make that determination and look to the record of the lawsuit. But that being the case, the state's lawsuit was about Boyce's dropping water levels in the winter of 2018 and also 2019, causing harm to Wixom and Sanford lakes because it did not want to pay for winter maintenance on the dam. And the only thing the two issues have in common is that Boyce, yet again, was prioritizing its own profits over the safety of nearby property owners. Now, in terms of how the lake level was set, the Four Lakes Task Force in Midland and Gladwin counties filed a petition to establish a legal lake level in separate litigation that was filed in 2019. And as a result of that legal action, the Midland County Circuit Court and Gladwin County Circuit Court entered orders setting the level of Wixom Lake. Boyce never indicated it could not safely maintain those lake levels in the spring, and always planned to do just exactly what it did, which was raise the lake to those levels in the spring of 2020. And thus, by orders of those courts, Boyce was required to maintain a certain lake level. The state did not try to compel Boyce to do anything otherwise. Now, since taking office, I have been aggressive and persistent in pursuing private entities when their actions threaten to harm the health, safety, or welfare of Michigan residents, especially in the environmental arena. The suggestion that I somehow care more about mussels than I do about people is absolutely false. And in my opinion, frankly, defamatory. This false dichotomy was created simply so that my political opponents could coin what I believe is a very inane catchphrase, apparently because Dangerous Dana just wasn't working for them anymore. But more than that, let me say, these types of statements are especially harmful because they perpetuate the very dangerous myth that environmental regulations that seek to protect natural resources and wildlife somehow do so at the expense of people. And not only is that untrue, but it wholly ignores the fact that many environmental regulations are an absolutely indispensable part of protecting our state's residents as well as their properties. And in fact, this dam failure is a concrete and incredibly unfortunate example of when an environmental regulation intersects with and plays a critical role in protecting the public safety. If Boyce would only have abided by state and federal environmental laws, thousands of residents in Midland County and the surrounding areas wouldn't have had their homes, businesses, and personal belongings damaged or destroyed as a result of the dam failure. Now, ultimately, though, whenever private entities own public infrastructure, there's a very real danger that profit will take priority over the safety of the public. And that is why, in order to best protect the public, the legislature must act to strengthen our environmental laws and invest in regulatory efforts so that we have both the tools as well as the resources that we need to prevent these disasters from occurring in the first place. Now, the importance of our natural resources absolutely cannot be overstated. Our residents depend upon them, whether it's for clean water to drink, clean air to breathe, or meaningful opportunities to make a living in industries like tourism and hunting, fishing. Our natural resources are the foundation of our economy as well as our well-being. And that's why it's absolutely critical that we invest in ensuring their continued safety and viability, and why environmental regulations are a critical part of safeguarding our residents' safety and their well-being. Now, with that being said, let me tell you a little bit about the lawsuit we just filed. This suit seeks to hold the dam owners accountable for the damage they caused and to recoup the money the taxpayers have spent responding to the ongoing emergency created by this devastating flood. We know the owners of the dam, with their long history of neglect, are responsible for the dam's failure. And we can already see the devastating results of their inaction. This suit seeks an order requiring the dam owners to pay to remediate the harm they caused and to take action to ensure that it never happens again. The suit will also seek immediate relief from the court to hold the owners' feet to the fire regarding the remaining portion of the Edenville Dam on the Tobacco River side of the dam. That portion has become a public safety hazard, and it is still holding back a lot of water and is still showing many signs of weakness. True to their past behavior, though, the owners have delayed their response and have yet to get even an engineer on site to do an assessment of whether immediate action is necessary to protect public safety, something EGLE had required them to do by May 24th, 2020. Now, we are asking the court to act quickly to impose enforceable deadlines on the owners to ensure that the remaining portion of the dam does not end up causing yet even more devastation. And I'd like to conclude my remarks by making one more thing very clear. The state is not seeking to delay or impede the efforts of Michigan residents trying to recoup money from Boyce based on the loss of their homes, businesses, or their personal property. Boyce absolutely should pay every single solitary person who has been impacted by the dam's failure. Instead, this lawsuit is intended to ensure that Boyce's neglect does not further harm local residents from a breach on the Tobacco River side of the dam. It also seeks damages for the violations of law that Boyce has committed. And we must send a very clear message to all those private entities whose own public infrastructure, we must tell them this: if you choose to place your own interests above the safety of the public, then you will be held accountable to the fullest extent of the law. And with that, I will now turn things over to Director Clark.
Great. Thank you, Attorney General Nessel. So I'd like to share a bit about, from my perspective, why we're here today. So on May 19, 2020, I was notified that the Edenville and Sanford dams were at risk of failing, following an exceptional rain event that produced 8 inches of rain over 48 hours in parts of northeastern Michigan. At the time of the failure, the EGLE team was on the ground assisting local officials with decisions and efforts to ensure that lives would not be lost. Although the eventual failures forced the evacuation of thousands of residents and created catastrophic flooding and property losses, I am so grateful that no individuals lost their lives. These dams were a part of a series of 4 consecutive dams. In addition to losing the Edenville and Sanford dams, 2 other dams regulated by FERC on the same river system, the Smallwood and Secord Dam, experienced erosion concerns. There are a lot of questions being asked by all of us. We all want to know what caused the failure and who's responsible. I'm committed to ensuring that we receive those answers. While a lot of scientific investigations are yet to be done, there are things that I can tell you today with certainty. First, the history of the Edenville Dam is complicated. EGLE inherited regulatory authority over the dam in the fall of 2018. On September 25th, 2018, FERC revoked the federal license to generate power at the Edenville Dam because the owners of the Edenville Dam refused, among other things, to follow FERC's orders to increase the dam's spillway capacity to handle severe floods. When regulatory authority over Edenville Dam transferred to the Department of Environment, Great Lakes and Energy, or EGLE, our team largely started from scratch in assessing the dam, as most records were protected from disclosure due to the federal critical infrastructure laws. Irrespective of whether the dam was regulated by FERC or regulated by EGLE, Boyce was responsible for properly maintaining and operating the dams in accordance with state and federal laws. They failed to do so. In fact, they ignored regulators for more than 14 years. Second, EGLE has been appropriately taking action to address concerns with the dam. Because of Boyce's history of ignoring federal safety rules, EGLE was forced to take a multi-pronged approach to ensuring needed improvements at the dam were made. EGLE was actively helping facilitate the transfer of ownership from Boyce to Four Lakes Task Force, a local stakeholder group that was seeking to improve the dam's infrastructure and restore its federal hydro generating license. That process promised a much faster path to fixing the dam than enforcement actions that could have taken nearly a decade of legal wrangling to result in improvements, particularly given the company's refusal over 14 years to comply with federal directives. EGLE had completed an initial analysis of the dam that likely indicated deficiencies in the spillway capacity. EGLE was awaiting a comprehensive engineering analysis to confirm those initial conclusions when the disaster struck. This analysis was critical to ensuring we had adequate and defensible information that would be used to enforce safety rules should the Four Lakes Task Force deal get derailed. EGLE was acting on laws that we were able to immediately enforce. When Boyce illegally lowered lake levels, resulting in environmental damage, EGLE acted. This enforcement action did not replace the work EGLE was doing to address concerns about dam safety, but it underscored EGLE's commitment to holding Boyce accountable. Now we are unfortunately dealing with the consequences of Boyce's disregard for the law. EGLE is now providing assistance to the affected community by engaging in various cleanup and assessment efforts, including our teams on the ground collecting sediment samples along the river to understand the impact the flooding had on dioxins and other hazardous materials that were being remediated and managed prior to the flood. Our drinking water engineers worked during the flood and are continuing to provide assistance today to ensure that adequate measures are in place to protect drinking water supplies and the public who depend on them. EGLE is actively working with Dow and other impacted industrial facilities along the Tittabawassee to evaluate impact and determine if there were releases that need to be addressed. EGLE has been involved in debris management by issuing guidance and proactively issuing waivers to allow waste movement across county lines so waste materials created by the flood could safely and quickly be addressed. And the EGLE team is working with local officials on the ground to offer our support to county emergency managers and others during this challenging time. Finally, we know there are a lot of questions about next steps. I will be speaking to these efforts over the next few weeks. They include an investigation, a possible dam rebuild, the effect of the flood on dioxins and other contaminants that were disturbed during the floodwaters, and the adequacy of our dam safety program, among others. These processes will take some time to complete. Please bear with us and understand, to do this right, it's a marathon and not a sprint. It's time for Boyce Hydro to take responsibility for the dam and for their historic lack of action. Boyce must stop running from their responsibilities as an owner of a high hazard dam. They were responsible for the dam's design. They were responsible for the dam's maintenance. They were responsible for the dam's safe operation. Our legal action today demonstrates our ongoing demands that Boyce take proactive steps to assess and secure potential safety hazards in the wake of the collapse. This includes addressing a sizable crack in part of Edenville left standing that poses a potential risk of more damage if it were to fail. Consistent with their history, Boyce is slow walking that process, another example of the company's casual approach to safety concerns. EGLE's focus and primary priority was and always will be public safety. Media reports based on false allegations in a lawsuit filed by Boyce that suggest otherwise are baseless and insulting. It's laughable that Boyce is trying to deflect their responsibility onto others. It's time for Boyce to take this situation seriously. It's my hope that this lawsuit will open their eyes and help us all move forward. Next, I'd like to introduce to you Director Dan Eichinger from the Department of Natural Resources.
Thank you. Good afternoon, everybody. In addition to the human lives that were damaged and disrupted and the property that was destroyed as a result of the recent flooding, the damage to natural resources from the flood and from the past actions of Boyce Hydro have been extensive. And this includes damage to our fish, our wildlife, our wetlands, as a direct result of Boyce Hydro's willful negligence. And these losses are in addition to, not in lieu of, the losses sustained by the people in these communities. It's important for the public to know that this has never been a choice between guarding health and human safety and protecting our natural resources. Boyce wants to paint that picture and wants to make those two values mutually exclusive. They are not. The natural resources of Michigan belong to the people of Michigan, and those natural resources are of vital importance to everybody, including those who live on or near the area where this flooding occurred, peoples whose lives, property, and environment were damaged by this company's negligence. Boyce Hydro owes compensation to those affected for all of these losses, and that includes the people of the state of Michigan. The purpose of the state's first lawsuit against Boyce Hydro was to seek relief for damages done as a direct result of Boyce's decision to lower lake levels. Boyce chose to lower lake levels not because the company was concerned about the conditions of their dam, but because company leaders didn't want to spend the money to clear the ice in the winter. In fact, Boyce drew the lake down over the objections of the state, landowners, and a circuit court order. Despite claims from Boyce Hydro to the contrary, the state did not have a role in setting water levels at Wixom Lake. And as mentioned by Attorney General Nessel, those levels were set by the circuit courts, not state agencies. The dispute over illegal winter drawdowns that killed mussels and other fish and wildlife has no bearing on summer lake levels. At the time of the dam failures, the lake was at its court-ordered summer level. State regulators never sought any increase in summer lake levels, and Boyce never indicated that the court-established summer level posed any threat to the dam's integrity or public safety, and never made any requests to the state to lower the lake level for this purpose. And any suggestion from Boyce to the contrary is just false. As I've stated, damages to natural resources as a result of Boyce's negligence were extensive. They are extensive. The company's actions resulted in the death of thousands, if not millions, of freshwater mussels and other organisms that are a critical part of the lake's ecosystem. It's been clear throughout Boyce's ownership of these dams that the company has prioritized the bottom line over people and its own interests over the interests of our natural resources. The company's failure to properly maintain the dam for so many years had a devastating impact on the lives of many and on the surrounding environment. And today's legal action is an important step in addressing that negligence and holding Boyce Hydro accountable for its actions. I turn things back over to Hugh.
Thank you, directors and Attorney General. At this point, we have a few minutes for questions, and we'd like to confine the questions to journalists only. I know there are some others on the line. If there's a little hand raise icon on your dashboard, I believe, and if you have a question, you can raise your virtual hand, and I should be able to see it. We're going to unmute Riley Began in a minute, Jim. Riley, if you can start us off by telling us who you are, what outlet you work for, and then if your question's addressed to one of the specific speakers, indicate that too, please. Thank you.
Sure. Thanks for the chance to ask a question. This is Riley Began. I'm with Bridge Magazine. This would be for Director Clark or Attorney General Nessel. The Four Lakes Task Force said this morning that EGLE did have access to that FERC information analyzing dam safety. You're saying that's not true. So my dual question is, do you still not have access to that information? And if so, can you tell us more about the challenges of getting it?
Yeah, sure. I'd be happy to speak to that. Thanks for the question, Riley. So, we are continuing to move forward and try to assemble all the data that's available. When we received, when FERC walked away from the regulatory authority over the dam, we were in a position of needing to recreate the history in order to get our two dam safety engineers into a position to be able to handle what a much bigger unit had been doing prior to that. So we worked with everybody involved, and in the course of that time, worked with external engineers who were doing this report and putting this report together. So the report is an important component. In the meantime, there were efforts being made to attempt to get things to continue to move forward from a regulatory perspective. So there is a lot of back and forth conversation, and what we want to be focused on is how do we get as much data assembled so that we can really support the investigation and make sure that we come to the right conclusions moving forward.
Thanks. So do you still not have access to that FERC data then?
Our team did reconstruction work over the course of the last few years and has worked with anything that FERC has been able to give to us. Some of it was kept confidential under critical infrastructure. So we've been recreating in the meantime. So specific questions about what our team has would have to go to our dam safety inspectors, but we'd be happy to continue that conversation with you offline.
Thanks so much.
Thank you, Riley. And I'm kind of going in order the hands were raised. I've got a Stephanie Parkinson. Jim, if you can unmute Stephanie, and Stephanie, if you can introduce yourself and your question, please.
Hi, my name is Stephanie Parkinson. I'm with the NBC and the Fox affiliates in Flint. Can you hear me okay?
Yes.
Okay. I wanted to ask a question more for informational purposes. I've heard that there's not a large staff dedicated to dam regulation in the state. I was wondering if anyone can answer how many staff members are dedicated to that responsibility, but then also wanted to ask about the Four Lakes Task Force is calling for an independent investigation. This is something that several groups have brought up now. Is that a consideration at the state level yet? I know you've talked about bringing in a third party. So what is that, I guess, in your opinion, compared to a full independent investigation? They are wanting it to be done by an organization that is an association of state dam safety officials.
Yeah, great question. So I'll work backwards. We've been working with the Association of Dam Safety officials for quite some time. Absolutely, they're a very credible source for understanding dam safety work across the nation. So we've been in contact with them immediately and continue to be in contact with them. And we'll have more to share publicly about what that investigation is going to look like in the next few days. But it absolutely will have an independent component. That is a critical piece of the work that we need to do going forward. The dam safety program in Michigan is 2 dam safety inspectors with some administrative support. So that is to oversee, and Hugh will correct me if I'm wrong on this, 1,100 dams that are within our purview.
Roughly speaking, yes. Thank you, Stephanie. I've got Jacob, and Jacob, I know your name. You're from MERS News. I'm not about to butcher your last name, so if you can introduce yourself, I promise I'll get it right when we converse again.
Sure thing. Thank you. Yeah, this is Jacob Kanzler with MERS News. I have 2 questions for you guys. Number one, it sounds like the lawsuit is looking to recoup monetary costs, and obviously there are some suits out there of residents seeking to recoup costs. And AG Nessel, you said you support the company paying that back. However, the company has said in the past that federal regulations demanding that they improve their dam, they weren't able to afford those. And so my question is, what confidence do you have that the company will be able to provide the relief that you have requested and repay property owners? I'll start with that.
Is that question directed to me? I just wanted to clarify.
Yeah, go for it. Yeah.
Well, I haven't reviewed Boise Hydro's financial background to know exactly what they have or what they don't have, obviously, but we've made clear the fact that we think first and foremost that it's important that those who had their lives destroyed, those who had their homes destroyed and their property and their businesses destroyed, that their needs ought to be met first, and that is a priority for us in regard to this. Anything that the state does, that we want to see that indemnification come first and foremost, as well as, of course, their responsibilities to ensure that there aren't future dam failures that would create even more issues. Part of the discovery process, of course, is learning about what kind of financial aptitude the company has. They've made a number of misstatements, and when I say that, I mean seemingly all they make are misstatements. So what their perspective is that they have volunteered or offered at this point, I don't lend it a lot of credibility. And that is something that we're going to have to find out more during the course of the discovery process of this lawsuit, and I imagine the many other pending lawsuits that have been filed.
Sure. And one more question while I have the mic still. Some of you have mentioned the history of what you say the company is not following state and federal regulations. This is a question for any of the principals here, but is there a public policy interest in the state looking to acquire the dams that Boise Hydro owns, or the property they own, or supporting an entity that wants to acquire those dams and property?
Yeah, I'm happy to speak to that. So one of the components of the direction that was given to me by the governor is to spend time looking at overall infrastructure from a dam infrastructure from a state perspective. And so we're thinking through what would be the right way to offer up some policy recommendations there about things that might need to look different in our statute, things that might need to look different about our programs. Certainly, there was time spent on this in the 21st century infrastructure plan as well. So I think that, we can have a public policy conversation about what public policy should we have and what outcomes should that drive. So we look forward to that discussion.
Thank you. I've got Zach Gorchow from Gondwer. Zach, If you can unmute.
Good afternoon, everyone. Thanks for the call. I'm wondering, since the state of Michigan has been named as a defendant in a number of lawsuits that have been filed following the flooding as well, how will the state defend itself in those suits, since it was the regulator of the Edenville Dam? And while there was work ongoing to figure out what the situation was with the dam, that corrective action did not occur in the more than a year since the state became the regulator. I understand that Boyce is obviously the owner and that they had a long reputation of slow walking or defying federal oversight, but the state is now on the line here in court as well.
Yeah, so there'll be more to talk about. Zach, great question. There'll be more to talk about in the next few days about what the structure of that investigation will look like, but it absolutely will include a third-party component. You're totally right. There needs to be an outside look at everything that happens. And so we'll be ready to talk about that more shortly. I'm pretty pleased with the progress that's ongoing. So can't wait to share that all with all of you and see what kind of questions you have at that point.
So I guess if I could just quickly follow up, I mean, I'm sure the Boyce people will say, well, yes, of course the state is going to blame us entirely, because if the state were to be found at fault, it would be facing, a massive potential judgment or settlement or whatnot that it would have to make with the owners. That the state here is doing its fiduciary duty of protecting its position. Can either Director Clark or Attorney General Nessel, can you speak to that?
So, I mean, there's two questions here, right? So obviously the investigation needs to be ongoing. We need to understand from forensics evidence what are the data, what's on the ground to help us understand why this happened. But in the meantime, we know what happened, and what happened is clear that, the dam was breached. And we know that given the facts that are in front of us now, we know we have more to collect. But given the facts that are in front of us, we know what laws were broken. And so we feel very confident working with our attorney that we're able to take this step. Attorney General Nessel, I don't know if you have more to say on that.
Well, I just find that to be an interesting position, because really, what is the claim that Boyce Hydro is making? You should have done more to make sure that we did what we were supposed to do, what we were told to do over and over and over again. Or you should have taken us over as an entity. You should have taken over the dam because we weren't responsible enough to own the dam and to do the many things that were required for anyone who owns a critical piece of infrastructure. What exactly is their contention? I'd like to know that it would be the state's fault instead of their fault. They clearly knew what they were supposed to have done. They were told over and over again, not just over the course of days or months or years, but for decades. They were told what they needed to do to ensure the safety of this dam, and they outright refused to do it. And then to say, well, it's somebody else's fault that we didn't do all the things that we knew we were supposed to do, I find that to be a ludicrous assertion. Now, we've talked a lot, and I know you've heard in the past few weeks, you've heard the governor talk a lot about maybe this points to a reason why private entities should not be permitted to own and operate critical pieces of infrastructure. That might be a thing that obviously we should be talking about more in the future. But in the meantime, obviously, that is the state of the law, that they are permitted to own those critical pieces of infrastructure. And I will say furthermore, you can't have it both ways. You can't, on one hand, have some of these same, I will say, political operatives that make statements like, you should have done more to prevent this. You as the state should have done more to prevent this disaster from happening. But then when we do file lawsuits, for instance, a lawsuit that I might have filed to try to prevent a bad actor that owns a critical piece of infrastructure who has not maintained that piece of infrastructure correctly, from allowing a catastrophe to occur, that you shouldn't be engaged, that's overstepping for the state to be engaged in that kind of conduct and in that kind of litigation. You can't have it both ways. So I fail to see or understand exactly what the defense of Boyce Hydro is, when everybody knows that they were told over and over and over again what they needed to do to maintain these dams safely, and yet failed time and time again to do that.
Thank you, Attorney General Nessel. I think we're overdue, but I'd like to get to one more question from Keith Matheny from the Free Press, if you might unmute him. Jim.
Good afternoon. I've heard multiple times today that the state had no role in the raising of the Wixom Lake levels to their summer levels this spring. However, I think Director Clark mentioned that the EGLE staff had done some preliminary evaluation of the dam after taking over the regulatory responsibility. They did understand the spillway problem. They did understand, I believe, the history of FERC's narrative on the spillway problem. Could not EGLE have gone, either not issued the permission to raise those lake levels or gone to court and said, perhaps they shouldn't be raised so high because of our concern here? Or perhaps could the summer lake levels have been raised later, maybe into June, to avoid this rainy season we've been having spring after spring, and of course the record water levels we have going this year?
Yeah, that's a great question, Keith. We certainly can have more conversations about regulatory authority and what is within the capacity of the statutes that govern the dam safety program. In the meantime, when you look across the state at our thousands of dams and our homeowners that live along some of those impounded waters, thinking about, what would happen across the state as we, as the state comes in and, attempts to overlay what folks' water levels should be. I think that's an important policy question that I imagine, a lot of folks would have strong opinions about. But we certainly would be happy to talk more about what is our authority under statute right now, and then certainly would be open to any conversations about future authority that the legislature might be interested in changing.
Thank you, Director Clark. I appreciate that folks have a lot of other questions or a lot of hands raised that we're not going to get to. I just got word that the press release, which has a link to the actual filing, the text of the lawsuit is out, so you all should get it. If you don't have it, let us know. On that press release are public information contacts for all three of the agencies represented here today. So if you have follow-ups, please direct them to the appropriate agency. Directors Eichinger and Clark, Attorney General Nessel, thank you very much for your time, and everyone else who was on there. Appreciate it.
Thanks, everybody.
Thanks.